Thank you, Mr. Chairman. I think one of the issues, and I think this, I'm glad we're discussing this today, but I think it's in a different context after the, the Heartland decision now. I think, we sort of leave it to where the courts have now said we're going to go, whether it's in the good professor's determination that you're just making it to a smaller, just maybe a percentage higher, or is it going to actually, make a difference in some other areas? I think we'll deal with that, but I want to get back to ultimately, I believe that legitimate litigants benefit from lower cost. I think whether it's a big, large company, small company, the startup inventor, the tech company, the content, this is an issue that we've got to deal with, because I firmly believe, and if you've ever, if you've listened to some of my concerns here, is that you got to protect content, you got to protect the patentability, you got to protect those issues. Subject matter is going to be an issue here. How do we determine that? But also, how do we make sure that the protection of that is also good for the process as a whole? So my concern is dealing with things as we look beyond venue and forum shopping to the real things that I have talked to, whether they be tech companies, traditional companies, or the smaller companies that end up on the lower end of some of these cases and being dragged into them. My questions become more of, why can't we begin to look at what many general counsels offline will begin to talk about? They want to talk about expedited Markman hearings. They want to talk about discovery reform. They want to talk about subject matter issues. They want to talk about motion practices in general. Let's look at customer stay. Let's look at those kind of things. Because at the end of the day, we're going around the edges of something that is, frankly, and whether it be, and I appreciate my friend, and I do believe that there's a punitive nature to attorney fees, and that's fine. But at the end of the day, most companies, and if you took and there's a lot of representing companies of tech and everybody else, I can see you in the room, which would you rather do? Worry about getting your attorney's fees and slapping at the end of the thing, or getting this thing stopped early? Getting a frivolous lawsuit out of the system early, so that we can get to legitimate cases that do need to be solved and do need to be settled. Litigants benefit from that. So, Ms. Chan, I'll take that. I'm sort of opening up. You've had a lot of specifics today. I'm sort of opening this up a little bit more, and I'd like for you, Professor, to start. Talk about some of those that actually, if you talk to GCs, you talk to general counsels in many of these companies, this is where they would rather us focus. What's your thoughts?
So it's a great question, and I think, again, what companies want is certainty, and they want to be able to report up to their CEOs that this is what we're looking at in terms of exposure. And they don't want to say that this case is hinging on, again, this bad luck of being sued in this one district. So it's really not about the concentration issue that is the issue. The issue is that once you know you're stuck in the Eastern District, that's going to be a certain amount of money that you pay no matter how bad the suit is. You're going to just be stuck with that bill. And it's outrageous for a lot of firms that feel like they would rather fight this suit, but they can't because it just makes a lot more sense to settle it. And so that's what creates the incentive for companies to continue coming up with business creative approaches, having the least cost operations, and still be able to bring their suits there. So I think that what I can see, though, in terms of all the different interventions Congress has come up with, again, going back to IPR, thinking about joinder, thinking about what the courts have done, what companies gravitate towards is certainty and efficiency. So whether it is a Alice 101 motion for a patent that clearly should not have been issued, is no longer patentable, and be able to get in there and get out in $50,000 to $100,000 early, or it's being able to say, well, I know I'm going to be in inter-parties review, and it's going to be an 18-month period. That's certain. I know that. Or even the ITC provides that certainty in terms of time frame. I think that's what firms are looking for. They want to be able to get on with the business of what they're doing, innovating, rather than trying to figure out how to manage this lawsuit. And
Ms. Anderson, I want you to jump in, Ms. Anderson, on this, but I want to take something you just talked about. Just briefly touch this, because I've touched on this, and you would believe the sort of the hair that went up on the back of some folks when you just simply talk about subject matter 101, Alice. You start looking at this and saying, but the question is, I think that we're getting into a conflation here of 101, 102, 103, 112. We're getting to how do you determine that patentability issue? And look, I'm not wanting to throw this out, but I think that's a discussion to be had, so I appreciate you bringing that concern up. Ms. Anderson, you had a point.
Well, you're asking what general counsels think, and I am one of the general counsels of a small company. I'll tell you what, my biggest concern is we cannot afford to try one of these cases. I'm told they're $3, $4, $5 million. We cannot afford it. So we need a way to get out early, and the 101 Alice is one of those. But when someone says you can't put a day or a time in a text message that goes out, you're violating our patent, and I say, that can't be true, and they say, well, let's go to trial.
Yeah.
I need to be able to challenge that. And if we can't get rid of that case early, we can't afford to challenge it. In that particular case, we paid them, I can't tell you how much, a large amount of money for that silly patent claim. We had no choice.
So at the end of the day, it doesn't, I mean, and we can talk about a lot of issues, and attorney's fees and all these are always talked about, but at the end of the day, for you, that's an irrelevant issue for you. And in some ways, if you could punish because you can't go through the process to
We
get
can't
there.
go through the process. We can't go through the process. The attorneys, the attorney we hired right now, $900 an hour.
Yeah, I appreciate the chairman and the subcommittee chairman, and also from both members of the aisle, sides of this aisle. This is an issue that we want to address in a proper way. And I think, frankly, the issue here is we can deal in the pieces, but at the end of the day, we got to start on what actually. It's like almost another issue we have around in healthcare. What are you doing to bend the cost curve? What are we actually doing to get litigants protected, the small vendor protected from the big, and the big protected from just frivolous suits? And I think we got to go to some issues. Venue was definitely an issue that the Supreme Court's addressed it. Now I think some of these discovery, motion practice, customer stay, Markman here is all get to what you're looking at, and I appreciate
Extremely
it.
important, yes.
Appreciate it, Mr. Chairman. I yield.